On April 23rd, the Federal Trade Commission approved the final version of a rule that voids and bans non-compete agreements for almost all employees and independent contractors nationwide. Once the rule is published, businesses will have 120 days to comply. However, as discussed in our prior coverage of this topic, it's unlikely the FTC has the legal authority to issue this type of rule. There will be legal challenges and injunction efforts to prevent the rule from taking effect. In fact, the first lawsuit to block the rule was filed within hours of its approval. Other employers and interest groups have announced plans to take similar action. Still, everyone should be aware of the scope of the final version of the rule. Here's a brief summary.
The FTC's rule would prohibit employers from entering into new non-competes with any employees, independent contractors, or other workers. It would also void existing non-compete agreements with workers other than senior executives. The rule defines senior executive as a worker earning at least $151,164 in total overall compensation per year who holds a policy-making position. Policy-making position is narrowly defined as a business's president, CEO, or other officer or person with final authority to make decisions controlling significant aspects of the business. So a current worker who only has the ability to advise on or influence these decisions, or only has final authority to make decisions concerning a subsidiary or affiliate of a larger common enterprise, cannot be subject to a non-compete. The rule also has a notice requirement. Employers would have to contact non-senior executives who are subject to a pre-existing non-compete to tell them that it cannot and will not be enforced. The rule has very limited exceptions. Non-compete agreements would still be allowed for individuals in the sale of business context, but only if entered into in connection with the sale, and only if the person is selling their ownership interest or substantially all of the business's operating assets. The FTC's guidance states that repurchase rights or stock redemption programs do not qualify as a sale of ownership interest under the rule. Further, the rule does not prohibit lawsuits to enforce non-competes that accrued prior to the effective date of the rule. It also does not prohibit employers from enforcing or attempting to enforce a non-compete or representing that workers are subject to a non-compete if they have a good faith basis to believe the ban does not apply.
The FTC's guidance clarifies that the ban goes beyond pure non-compete clauses. For example, forfeiture for competition and paid post-employment garden leave clauses are also prohibited. In addition, while confidentiality and non-solicit covenants are not strictly prohibited, if they are drafted in a way that is overbroad, they may also be considered unenforceable. For now, given the current and expected legal challenges to the rule, companies should hold off on making changes to their employment agreements, non-compete provisions, or other restrictive covenants. Instead, employers should stay focused on making sure their non-compete agreements are enforceable under applicable state law. We also recommend keeping an eye on the litigation challenging the FTC's rule. Links to prior LaborSpeak videos discussing non-compete developments are included in the description section of this video. Feel free to contact our team if you have questions about the FTC's rule or any other issues relating to non-compete agreements.